to interpret and the Second Amendment.
So, I mean, you argue then the well-regulated militia being necessary to security of the state is more important than the right of people to keep their arms and not being charged. Why should we take the first clause and not the second? I'm going to ask you that. Why preference one clause over the other? Because that's what you're asking us to do.
The clause is not even an issue. I believe that what the issue is relating how the Second Amendment is written, including the very relevant court, but to modern day society. Militia in modern day society is no longer we don't have, backyard militias to fight off.
Well, let me follow that train of thought then. If that train of thought isn't true, we can ban all of them, right? Anything. Only the military. Because if the militia doesn't exist now, then the Second Amendment is no longer valid. So we just throw it out. It's not relevant at the time. Everybody must give up their gun. So what's your argument?
No, because in 76 when those enacted, the guns previously owned by, I want to say, 64 grandfather in district. If you had a gun registered, then it wasn't going to be taken away from you. Of course, you would have done something like this, no one was already taken away. But with
it's not only the legislature, but where we can place the cases.
within each state or within the municipality. If you see, I would think it would be based off of where the town is in St. Louis.
So your argument is local.
Take away the power from the government, from federal, and put it in the local government.
The Omnibus Crime and Control and Safe Streets Act from 1968 states that Congress finds further that crime is essentially a local problem and must be dealt with by state and local governments and is to be controlled effectively. So this act is stating that in order for to protect the peace, security, and general welfare, the local and state governments must take a hand in it.
So are there any limits to what the local government can do?
So local governments can interpret the Constitution the way they want to, and other governments can interpret it a different way.
And override the Second Amendment.
Time's up. I'll still give you 4 minutes. I want to answer that question.
It wouldn't be overriding the Constitution, it would be within the free spirit of what we argue, because the interpretation is so confusing, basically. So many cases have argued Miller versus the United States. They argued it and didn't come to the second conclusion of whether it's the well-regulated militia part, whether it's collective versus individual. It's a concept that's just been thrown around. And in this case, we are forced to look at how the individual right is.
Go ahead. We'll reserve your 4 minutes. We'll just kind of like respondents.
Thank you, Mr. Chief Justice, and the police report. February 2003, 6 residents of Washington, D.C. filed a lawsuit in the district court to challenge the constitutionality of the provision of the Firearms Control and Regulations Act, 1975. This law bans residents from owning handguns, automatic firearms, and high-capacity semi-automatic firearms, as well as prohibiting possession of unregistered firearms. The district court for the District of Columbia dismissed this case. The U.S. Court of Appeals for D.C. Circuit reversed dismissal in a 2-1 decision. The court determined that the Second Amendment protects an individual right to keep and bear arms, with the right premised on the private use of arms for activities such as hunting and self-defense, the latter being understood as resistance to either private lawlessness or the depredations of a tyrannical government or oppression abroad. Although they felt that Second Amendment rights were subject to reasonable restrictions, they determined that handguns are arms and not
Just said that you need reasonable restrictions. I don't think you're going to argue that we should have guns in school. There should be certain places where guns aren't allowed. DC has a crime problem, a murder problem with guns. Wouldn't it be reasonable to restrict those?
Well, Once the Firearms Control Regulation Act was passed, before it was passed, the murder rate in D.C. was 15th among America's most 50 most popular cities. In the first 15 years after the ban, the murder rate was first or second.
Do you have any data showing anywhere that murder rates were lowered when handguns were legalized?
Well, using the data, because it's interesting to me that both sides are using the same bit of data to argue opposite sides. Are you arguing that because the murder rate went up that the law is ineffective?
We are arguing that nationally instead of locally, that there's no sufficient evidence to prove that the law has reduced the murder.
So if it was effective, it would be constitutional. So constitutionality is just based upon effectiveness.
Based on that, then I mean, you get rid of speed limits.
The things that we have rights to can be subject to limitations, but not necessarily prohibition, which is what is taking place with the Firearms Control Regulation Act here at D.C. So, given being able to the statistics, I would say that it is ineffective, but I don't know.
Is the fact that it's ineffective a reason to change or alter the interpretation of the Constitution, or keep the interpretation of the Constitution the same way?
Whatever works, but if they keep more.
Let's say that it is for the greater good of a majority of Americans that Congress establishes Christianity as the official religion of the United States. For the greater good, because the majority is effective. According to your line of argument, yes, they can. As long as it's effective, it's okay. But so if the crime law was effective, then it would be okay. I guess I push this because in the amicus brief in this case, overwhelmingly all law enforcement agencies are in favor of handgun bans. They're on the front line. They're dealing with crime every day. They think a handgun bans, not just in D.C. but across the nation, would be effective in helping reduce crime. If they're on the front line and they're arguing for it, they think it would be effective, and I am not a police officer, so I'm going to defer to their expertise in the situation. Why then would it not be effective, and according to your reasoning, therefore constitutional?
Well, handguns are necessary for self-defense.
Where's that right in the Constitution? I don't see it right.
Why doesn't the legalized rifle or any other legalized weapon, why isn't that good enough? Why does it have to be a handgun?
I'm not sure what you mean.
What we're arguing here is to legalize handguns. We think you can already have other weapons such as rifles. Why isn't that sufficient?
Rifles are generally used for hunting. I don't have much experience with them, but I would imagine it's easier to pick up a handgun and defend myself than to use a rifle.
Right to self-defense using a gun. I don't know where that is in the Constitution. The originalists, the people at the time, didn't argue for a right to self-defense. Yes, some of the state constitutions had it. But, for instance, Massachusetts, they had a regulation that guns and ammunition must be stored in a separate room. And actually, if you had a two-story house, the ammunition had to be on the second floor, and the gun had to be on the first floor for fire protection. So that's not self-defense.
Well, to defend yourself against a criminal, criminals will get guns illegally and will take them.
Two wrongs don't make a right.
Are we talking here criminal breaking into a house? That's what we're looking at, correct? When you say protect yourself. Do we know on these stats, on these murders, how many of these were in-home invasions where a handgun, the lack of a handgun, caused